Hey all, welcome back to the Laureate Slowly. I hope you have been revising and have been in touch with your notes and the subject over the past 1 week. I want to begin by thanking everybody who wrote to me. A lot of you wrote to me after the last session, especially that you have really started finding the subject of CPC easier than you first found it, or that you have started finding it interesting. I don't know what triggered it after the last session. Maybe the fact that we discussed so many hypotheticals, and I am going to uh, feel satisfied in the fact that maybe you guys wrote to me because you were able to crack those hypotheticals during the session in your own mind. And maybe that is the trigger that made you realize that you are actually able to understand CPC better and are able to deal with it in a factual scenario as well, which is the whole point of law, that you should be able to apply it to society and be able to deal with it in the practical scheme of things. So, whatever may have been the trigger, I'm not questioning it. I am just happy to know that you guys are enjoying the sessions and that you're gaining from them. So, it makes this whole exercise worthwhile. Okay, moving on. So, in the last session, we were discussing meaning of some very important terms. We went on for two sessions and we discussed the meaning. We took ample amounts of hypothetical scenarios, and I gave you the time during the session to solve them. You solved them with me also, then I give the solutions also. And we saw all kinds of different hypotheticals, which also show you how CPC interplays with other laws like family law, other laws like Transfer of Property Act, other laws like limitation law. We saw a lot of examples and factual scenarios, and we solved all those problems throughout the session. And I know I gave you one hypothetical as a DIY. Uh, so I hope some of you definitely did it because you all wrote to me with your answers. And sorry, I couldn't respond to everybody, but I'll begin by giving you a discussion, and we will see the solution to that. And let's see how many of you were able to. I mean, most of you were correct. So let's see how many of you were able to, get your answers right after the long list of hypotheticals that we had discussed. Let me read the hypothetical out to you because in the last session I gave it to you on the screen, so you must have a copy of it. So I'll just read it out for you to refresh your memory, and then we will quickly figure out what is the cause of action, what is the subject matter, what is the title, what is matter in issue, what is the relief sought. Fine. So the hypothetical was Arav, an Indian designer based in Delhi, creates a unique couture collection titled Monsoon Geometry. He showcases this collection at a fashion event in London while he is visiting for a short academic program at University of Cambridge. During the event, a British fashion house, Regent Atelier Limited, expresses interest in the collection. Arav enters into a written agreement granting them limited rights to exhibit but not commercially reproduce or sell his designs in Europe. A few months later, Arav discovers that Regent Atelier has not only displayed the collection in London but has also mass produced similar garments, sold them across Europe and through online platforms accessible in India, claimed the designs as part of their own label. Arav files a civil suit in India seeking relief. Now, assuming all the jurisdictional issues are well settled and that the suit can be filed in India, I want you to identify the cause of action, subject matter, title, matter in issue, and the reliefs that RF can seek. So, what will become the cause of action here? Cause of action is what we have discussed at length now. There has to be a right, and there is a breach or violation of that civil right. What is the right that RF has here? The right that RF has here is his contractual right that he entered into by way of the agreement. That agreement gives him that contractual right that his designs are his own, and he has the liberty to decide what can be or cannot be done with respect to his designs by the regent atelier. So that right has been laid down in the contract. So the right in question is his contractual right over his designs and over his IP, intellectual property. These designs are intellectual property of Arav, right? The intellectual property law gives him this right. So it is a contractual right which is also recognized by the IP law. Now, what is the violation? So the violation is clear. All the things that he had not allowed them to do by way of contract were done by Regent, and hence they violated rights of Arav. So what were these things? They mass produced the similar garments, they sold them across Europe and through entire world by way of online accessibility. And they claimed that these designs of Arav were actually their own designs. So it's a clear violation. So cause of action we have established. What is the subject matter here? We've discussed subject matter is what? The thing with respect to which the civil suit has been filed. Here, what is the thing that Arav is trying to protect? The rights, the intellectual property rights that he has over his designs. So that those rights will become the subject matter here. We've discussed that subject matter can be proprietary, it can be monetary, it can be a right also. So here, subject matter is Arav's IP right. So what is the title that he can use to claim? What is the title? What is the capacity which gives him any kind of ground or locus to even file this suit? He is the right holder. That is why. So right hold, he's him being the right holder, him being the creator. How does he? Why does he have this right to file it? Him being the creator, that's what his legal capacity is. He's the one who is holding this right because there's a contract and he's the owner of this right. What gives him this right? Matters an issue. The contract. The contract is what he will present. That see, this contract is the source for my title. This contract is what gives me this right to not get my designs exploited by Regent. Then what else can be the matter and issue? That the very fact that he's the creator of those designs. IP law gives you protection if you're a creator of those designs. So that becomes his matter and issue. Then finally, what reliefs can he claim? Of course, if they are misusing his design, misusing his intellectual property, the first thing that he would want to do is stop this misuse. So he will ask for a permanent injunction. Permanent injunction, but again, we've discussed permanent injunction comes at the end of the suit. Finally, the relief will be given. So while the suit is ongoing, should Regent be allowed to misuse Arav's intellectual property? No. So Arav will also file an application for temporary injunction, Order 39 CPC. So he can do that also. What else can he do? They have been doing this misuse for some time. So, of course, they have made some profits off of it. And RF has definitely suffered damages because of such misuse. So, what will he do? He will claim damages from Regent, mean profits, Section 2, subsection 12 of CPC. We've read it. What are mean profits? That you were supposed to earn these profits and the other party has earned it. The definition in CPC you see is in terms of wrongful possession of a property. But use that logic to understand why he's being able to claim damages over here. Because they've been misusing his property and they've been earning out of it. Whereas he's the one who should have been able to earn out of it. So we can do that. And what else can they do? So here you see they one of the misuses they have done is mass production of his garments, similar garments. So what? Can they say that, oh, since you have already spent money on mass producing these, let us utilize these and we will stop from moving further and we'll pay you damages and stuff? No. He can even ask the court that they order Regent to deliver up all those infringing articles that they have produced and get those articles destroyed so that they can't be put out in the market by Regent. That can also be a relief that he can seek. So now with discussion of this hypo, we are done with the discussion on the meaning of the term, 5 terms that we laid down: cause of action, subject matter, title, matter and issue, relief. Now, next topic that we have to begin with afresh is jurisdiction. Clear? Now, in jurisdiction, understand this first of all, that the whole point, you see today's legal system in India, it is so clogged, it is so overburdened. Now imagine if there was one court and everybody was just going and filing their cases to that one court. Now this one court is burdened with everybody coming there and filing their cases from all kinds of areas. So suppose the court is in Goa and everybody wants to go for a trip to Goa, and then they can be like, oh, now we can use the pretext of having a hearing over there, just go do that long pending Goa vacation also. So everybody will just go file their suits in this one court in Goa. So what will happen? This one court will be so overburdened that it will not ever be able to see the end of litigation. Everybody's going to go file the case over there. And what about a court in a non-touristy place? They'll just be sitting idle. Nobody will be filing cases there. Is that healthy? It's not. What about a court in a non-touristy place? They'll just be sitting idle. Nobody will be filing cases there. Is that healthy? It's not, because it will just lead to pendency of litigation. And a major tenet of the legal system, the procedure, is that the justice should be delivered in a timely manner. Speedy justice, Article 21 also of Constitution says it. So you need to have speedy justice that has to be done. How will speedy justice be done? By having just one court and everybody going to that one court. Court is also a limited kind of creature. It can't just sit and dispose of all cases at once. Judges are humans. That is why we need the concept of jurisdiction. What is jurisdiction? Jurisdiction is basically the ambit of power that any body can exercise. So in case of a police station's jurisdiction will be in its area. Can police station of Tamil Nadu deal with cases in Haryana? No. The area police station, the Ilaka police station, deals with the matters arising in its jurisdiction. In the same manner, all the courts in the country, civil courts, even criminal courts, all kinds of courts, they have jurisdiction. So they can only deal with cases from their area. Not anybody from anywhere can come and file a case in any court. No, because that ways, if somebody wants to file a case in some random location, they can just go file it there, and everybody loves that location, so everybody can just go file it there. That would absolutely lead to a ruckus of the legal system, of the judicial system, of the justice delivery process. That is why we have jurisdiction, which divides all the work that the courts have to do across the country. The jurisdiction essentially tells the court and also the people who are filing that this court can deal with only these matters. So if your matter is one of these matters which fall within the jurisdiction, which fall within the scope, within the power of this court, only then you come to this court and file your case over here. So if your case is not filing within the jurisdiction of this court, then don't come here. So if we are a court in Goa, and if your matter is in somewhere it's about some immovable property in Punjab, and that is where all the cause of action has arisen, then don't come to Goa and file your case over here. File your case in the court which is local to you, the court which has jurisdiction over your case in Punjab. Because that is how we will ensure that administrative side of justice is realistic. That courts are not just clogged illogically. That everybody is filing cases wherever their courts have jurisdiction. So the work gets divided. And that is how justice's wheels will be greased. Justice keeps moving, keeps getting delivered. Otherwise, one court burdened with all of the country's cases will never be able to move an inch. That is why we have the idea of jurisdiction. So you need to understand, why do we have jurisdiction? What is the purpose behind having jurisdiction? Because if you know the purpose, then stuck in a situation where you are supposed to think about the idea of jurisdiction, you'll be able to always apply the purpose behind jurisdiction. So even if you're sitting in a situation where you are supposed to, as maybe in an exam setting, supposed to decide that whether this court should have jurisdiction or not, the purpose of jurisdiction should be clear in your mind. Why do we have the idea of jurisdiction in the very first place? So jurisdiction is about deciding the ambit of the court. What kinds of cases can come to it? What area will it have its jurisdiction on? So anything happening in that area only will be dealt with the court of that area. For another area's court will deal with it. Don't come to us. That is why you have jurisdiction. Now I've told you jurisdiction is about fixing the limits within which the power of that court will be exercised. Now, how can this limit be fixed? So either it can be fixed area wise, that this court will only try cases that are arising within this area, that is its local area. So that becomes the jurisdiction of that court. Now, this kind of jurisdiction, which is set up on the basis of the area from which the cases can be heard by the court, is called territorial jurisdiction. So, first kind of limitation, so that courts are not clogged, is territorial jurisdiction. that only if you are from the local area of this court, then come to this court with your matter. Fine, that is there. Now suppose there's an area, suppose Bathinda, and there's a court over there. Now there's just one court in Bathinda, imagine, and it's catering to the whole of district of Bathinda. Now everybody, be it their 1 rupee case, be it their 100 rupee case, be it their 1 lakh rupee case, be it a 2 crore rupee case, is just going to this district court directly. Everybody's like, oh, of course, I want a good quality of justice. And I think a seasoned judge would be more fit for my case. So I'm directly going to go to the district court and file my case over there. Because district court has area jurisdiction. It has a territorial jurisdiction over my case. My case arose within the jurisdiction of Bathinda. So of course the district judge has jurisdiction to try it. So why won't he try it? I'm going to file my case over there. Anybody can say that, and it will be correct also, because all these people, their cases have arisen in the territorial jurisdiction of the district court of Bathinda, so they can all directly go to the district court and file the case over there. What will happen if the district judge? Again, the same kind of issue is arising, even though at a smaller level, but it's the same issue that everybody in the area is coming to district judge. So maybe there's a case of high importance, including huge amounts of money in it, and there's a case which is a petty offense, or which is a civil wrong, but not of as grave a nature as the other case. But everybody is there in the district court. Some cases have to be heard in a timely manner, otherwise the relief will be rendered useless. Then what? But there's just one court, and of course it has to now try because it has territorial jurisdiction. So to deal with this problem also, the law further provides another form of jurisdiction. So imagine this is a box, and then within it you have subdivisions. Consider it like that, different forms of jurisdictions. So you have territorial jurisdiction, which is based on the area in which your case falls, and if the case falls within the local area of that court, then that court can try it. But then everybody will go to one court only, the district court. Suppose everybody is going there, then what? That is why we have pecuniary jurisdiction. That is jurisdiction based on the valuation of your suit, valuation of your case. So for example, if you see in Delhi, a civil judge can try cases up to 20 lakhs or less than 20 lakhs. So if your case is of value under 20 lakhs or of 20 lakhs, then you have to file your case in civil judge's court. District judge who comes above civil judge in Delhi can hear cases only of the valuation of more than 20 lakhs and equal to 2 crores. So if your case is of 1.5 crore valuation, then you have to file it in district court only in Delhi. Every state has its own pecuniary limits, which are decided on state to state basis. The high courts usually decide it. So for every state, you will see there are these courts acts, Punjab Courts Act. You will see courts acts for every state. For Himachal also, you have a separate courts act. Every state has its own courts act, by way of which the pecuniary jurisdiction is decided that, okay, this level of court, civil judge will hear cases only up to this much monetary value. A district judge will hear cases only up to this much monetary value. And then if the high court has original jurisdiction, then it will hear cases up to this monetary value. I have already explained to you the concept of original jurisdiction and appellate jurisdiction in the previous session, so you shouldn't be confused now. We also noted down what are the 5 high courts in the country that have original jurisdiction. So